Good afternoon. Good afternoon. I'm Paul Carisse. I'm the director of this still fairly new school at Arizona State University, the School of Civic and Economic Thought and Leadership. And I wish everyone here a happy Constitution Day. I'm delighted to see so many people here. It's my honor to welcome you to the third annual of these Constitution Day lectures that the school inaugurated. We're grateful to have another very distinguished speaker with us this year. And we're also grateful to have members of the Arizona State University faculty and staff and students that I can see, and also members of the community who are here. I will note that in the first 2 years, we had more members of the O'Connor College of Law with us in the audience, including the dean last year, if I remember. But they are having their own Constitution Day event right now downtown. But we do have one member of the law school faculty, at least, if not more than one here. But I just saw him a few minutes ago, there he is, Professor Jim Weinstein of the O'Connor College of Law, who is a special friend of the school. He served for 3 years now on the planning committee for our major speaker series, and I'll say more about that at the end of tonight's event. We also have a visiting scholar with us in the audience, I want to note, Professor John Marenbaum from Cambridge University in England, who is a philosophy professor visiting with us for a couple of weeks, but he's also interested in the philosophy of law, and he will actually be speaking at the O'Connor College of Law next week. Just a few words about the mission of this new school, and a word about Constitution Day itself, and then I will introduce our very distinguished guest. The School of Civic and Economic Thought and Leadership is dedicated to reviving the crucial link in American higher education between a liberal arts education and civic education. We do this in order to prepare thoughtful leaders for civil society and for public service. And we're also dedicated to undertake civic education with the broader community and with K-12 public schools. And thus, on the way in or on the way out, I hope you will avail yourself of the opportunity to see another special guest we have with us here tonight, part of our Civic Classics collection. This is a first edition printing from 1788 of the Federalist, commonly or more popularly known as the Federalist Papers. And the escort for our special guest is our friend from the library, Kathy Krish, who has been the director of distinctive collections at the library. And she's retiring soon, so this is the last appearance, we think, on the ASU campus where she will be shepherding one of these rare items for us. This collection, the Civics Classic Collection, is a set of rare books and writings that we received some money from the state legislature to acquire in partnership with the library. Works about the themes of the school, great works of civic thought, of American political thought, of political economy, and of leadership. This is one of the earlier works in the collection, and at the very end, we have the tail end of the collection chronologically. We have 2 autographed copies of Martin Luther King Jr.'s first 2 books. And members of the audience should know that we invite especially school groups and school teachers to come to ASU to view items from the collection, and occasionally, don't tell Kathy, but occasionally when the library gives us permission, we can take the books out 1 or 2 at a time into the community. Speaking of students, we hope the students here will gather some information about the school outside our curriculum, but all members of the community here should gather some information about the school and spread the word, not only about our curriculum, our courses, but our public affairs programming. And of course, I hope we have copies out there. I didn't look of our, and I forgot to bring my own copy as a prop of our pocket constitution, our SCETL pocket constitution, which is distinctive in having not only it's the only one I know of in the country. If anyone knows otherwise, let me know. Has not only the Declaration of Independence and the Constitution, but we have the Gettysburg Address by Lincoln, 1863, and from 1963 we have Martin Luther King Jr.'s I Have a Dream address on the National Mall in Washington. The student who chooses to minor in the school has a chance to learn more, I would think, about the Constitution and the principles behind it than in many other places in higher education today. The chance to understand as well the fundamental debates which led to the Constitution and the debates that we continue to have about the Constitution and its meaning. And so a word about Constitution Day itself. It was established in 1956 by the Congress on September 17th because that was the final day in 1787 when the delegates at the Constitutional Convention in Philadelphia, with George Washington presiding, signed the final draft of the Constitution and disbanded the convention. Then in 2004, Senator Robert Byrd of West Virginia authorized legislation, sponsored legislation that requires public schools and governmental organizations to provide educational programs on or about September 17th to promote a better understanding of the Constitution. So we established this event 3 years ago to complement or supplement our curriculum so that we can promote better understanding and appreciation of our nation's fundamental law and of civil debate about it. So we posed the question, for example, was Frederick Douglass correct in 1852 when he referred to the Constitution as a glorious liberty document? This year, to help us understand the Constitution, we have a very distinguished scholar of constitutional law and a former federal appellate judge to speak with us about one of the distinctive features of this rather extraordinary document, the American Constitution, the feature that is a separate and potentially very powerful executive office. Michael W. McConnell is the Richard and Frances Mallery Professor and Director of the Constitutional Law Center at the Stanford Law School, where he also is a senior fellow at the Hoover Institution. From 2002 to the summer of 2009, he served as a circuit judge on the United States Court of Appeals for the 10th Circuit. Judge McConnell has held chaired professorships at the University of Chicago and the University of Utah, and visiting professorships at Harvard and NYU. He's published widely in the fields of constitutional law and theory, but most especially on issues of church and state, on equal protection of the laws, and constitutional structure. According to one recent study, his work has been cited in opinions of the United States Supreme Court second most often of any legal scholar during the past decade. Among his publications, he is co-editor of 3 books: Religion and the Law, Christian Perspectives on Legal Thought, and The Constitution of the United States. That's a book by that title, not the original document. Judge McConnell is a member of the US Supreme Court Bar and has argued 15 cases in the Supreme Court. He's also a member of the American Academy of Arts and Sciences, and in 2017, he was the winner of the Rex E. Lee Appellate Advocacy Award. He's also the recipient of honorary doctorates from Notre Dame University and Michigan State University's College of Law. He also served as a law clerk to Supreme Court Justice William J. Brennan, which I did not know until I wrote this, or our staff wrote this introduction. And he is today of counsel to the appellate practice of Kirkland Ellis. Tonight, he's going to give us a PowerPoint presentation and a talk based on a book project he's working on at the moment by the title of The President Who Would Not Be King. So with that, please join me in welcoming for our 2019 Constitution Day lecture, Judge Michael McConnell. Thank you.
Thank you very much, Paul, for that introduction, and indeed, several old friends here, and a welcome that I've received. I would describe it as a warm welcome, but actually I would call it a hot welcome based on where I have been. It's lovely to see such a large crowd here, and I'm really impressed as I've learned about this new program here at Arizona State. It seems to me to be an ideal addition to higher education, so I'm delighted to be here. My topic tonight is the presidency, and for Constitution Day, it's I think a particularly appropriate topic because the most dramatic moment at the Constitutional Convention in the summer of 1787 had to do with the presidency. It was on the 3rd day of deliberations. As you probably know, and I may be repeating for some, but just to remind you, at the beginning of the convention, when the delegates gathered, the delegates from the state of Virginia, the largest state in the Union, the state of George Washington, the state of James Madison, presented a plan. And they sort of caught everybody else by surprise. Everybody else came to the convention and they thought they would sort of noodle over some things, but the Virginia came up with a plan. And so on the first day of the proceedings, Mr. Randolph, the governor of Virginia, laid before the House for their consideration sundry propositions in writing concerning the American Confederation and the establishment of a national government, a plan that had 15 different provisions and is considered to be the first draft of the Constitution. Well, he presented the plan one day. The next couple of days, the debates turned out to be much more contentious and difficult than anybody had imagined, and it was really rather discouraging. And then on June 1st, so here's Randolph on the left. The real author of the Virginia plan was James Madison, but Madison was a rather short, bookish individual with a thin, reedy voice. So you wouldn't want him to present the plan. He couldn't speak very well. The records of the Virginia ratifying convention are somewhat amusing because frequently when Madison is speaking, the stenographer will just write, the remainder of this was inaudible. Randolph, on the other hand, was tall, young, he's 32 years old, handsome, of one of the leading families of Virginia, and a really charismatic figure, an important lawyer. I think he's none too bright, but you can be the judge of that. But I think of the two as, it's as if, Randolph is the president of the fraternity, and James Madison is the secretary-treasurer who does all the work. So anyway, Randolph presents this plan, and on June 1st, they got to the resolution that has to do with the presidency. And the resolve looks pretty innocent to us if you just look at what the words are, that a national executive be instituted, that in addition to a general authority to execute the laws, it ought to enjoy the executive rights vested in Congress by the Confederation. That's it. That's the entire description of the presidency in the Virginia plan. But I need to learn how to use this clicker. But almost immediately, the words barely get out of the voice of the presiding officer when Charles Pinckney of South Carolina interrupts. You can practically hear him sputtering. He's so concerned. So he's afraid, having heard this, you saw the words, he says he's afraid that those executive powers that are to be invested in this new part of the government, quote, might extend to peace and war, etc., which would render the executive a monarchy. Right, so peace and war, what does that mean? That means the executive can take the country to war on his own authority, just as the king could, can make peace on whatever terms he wishes, essentially controls the entire foreign policy. And then I love the etc., right? That's from Madison's notes. It means a bunch of other things just like that. And it would render the executive a monarchy. This, by the way, I'm not going to talk a lot about military issues tonight, but a major concern, both of the delegates in Philadelphia, but even more so during the ratification process, was the danger that a popularly elected president with control over the Army and Navy would be able to turn the country into a military dictatorship. The fear, they would refer to Cromwell and to Caesar, right? And both of them being popular leaders who used their successful control over the military to subvert the Republic. The two leading authors against the Constitution mostly they wrote under pseudonyms. One of them is Brutus, and another one is Cato. Who are they? They're the ones who arranged for the assassination of Julius Caesar. And what they're communicating is these advocates of the Constitution are like Caesar, and the Republic is going to be subverted. And so Pinckney sees the words of the Virginia Resolution, and he infers the danger that the country is going to be rendered a monarchy. Now, why would he think that? The words don't seem that dangerous to us. But look at them again. I'm sorry. So there are basically two powers, right? There's the general authority to execute the laws, and then in addition to that, there are all the executive rights that were vested in Congress by the Confederation. Note that those executive rights have to be something other than executing the laws. So this is when the executive gets to sort of go out on its own. So what are those executive rights? Well, in order to find out, you have to look at the Articles of Confederation to see what they were. And here's a list. Determining on, these are in the order in which they appear in the articles. Determining on peace and war is the very first one. So you can see Charles Pinckney, who knows what's in the Articles of Confederation, says all the executive rights are peace and war. It's the first thing he thinks of. Also sending and receiving ambassadors, which is control over foreign policy, entering into treaties and alliances, regulating captures and prizes. I don't need to read the whole list, but that's the list. Well, how do we know that those are executive? Because they're not labeled executive, that the word doesn't appear in the Articles of Confederation. The reason that Pinckney and others inferred that these were the powers of the Confederation Congress that are now going to be vested in a single person is that these were the powers held by King George III. Specifically, these are called prerogative powers. Now, prerogative is a word that has almost dropped out of the American constitutional vocabulary, although it's very hard to do away with it, and it's a very useful word. And what it referred to were powers held by the executive by virtue of the office. That is, not powers given by the legislative branch, but powers that the executive simply holds by virtue of being the executive. They're not created by the law, by statutory law. They're not regulated by statutory law. They're just things that the executive can do. Right? Most familiar examples to us from our Constitution would be the veto power. The president has the veto by virtue of being president. Congress doesn't give it to him. Congress can't take it away. Congress can't regulate it. He has got the veto power. Another example is the pardon power, another prerogative. He has it by virtue of being of office, by virtue of being the president. Congress didn't give it to him. Congress can't take it away from him. Congress can't regulate it. These are prerogative powers. And if you think about what prerogative powers look like, they're powers in which the president or the person who exercising those powers determines the purposes and the nature as well as the form of execution. So when the president executes or enforces a law passed by Congress, Congress has decided the basic idea, the basic theory, and the president is carrying it out more or less in accordance with congressional will. Prerogative powers, he decides the policy as well as the means of execution. And so well, this isn't a happy thought because that's think of what Charles Pinckney says. This will render the executive a monarchy because this is the characteristic of the monarchy, is a single person exercising a set of powers, many of which are, in addition to executing the law, are these prerogative powers, and the prerogative powers aren't controlled by the legislature. The policy isn't determined by the legislature. There is a broad scope of authority. And so, yeah, the monarchy is going to be an elective one, but it still looks an awful lot like a monarchy. And then Madison's notes, I have to chuckle at this. So a considerable pause, as soon as Pinckney speaks, a considerable pause ensues. It's the only time in the summer of 1787 when you don't have lots of people sort of jumping up and talk. Everybody has something to say about everything else. But as soon as this issue of the presidency and the elective monarchy potential, they don't know what to say. Now, why not? Well, part of it is that Pinckney has raised a very serious issue. This is important. The stakes are very high, and the answer is very difficult. How can you have an executive powerful enough to be able to do what he needs to do, both foreign and domestic, without his being so powerful that that it turns out to be effectively a monarchy? And especially, please bear in mind that one of the departures from the British system is that this president is going to be independent of the Congress. Eventually, there are a lot of debates before they get there. But when you get to the end, the president isn't chosen by Congress and isn't answerable to Congress. He's chosen by electors who are totally separate, right? And so he's going to be independent, right? And unlike in Britain, where the system is evolving, that sure, the king is independent in a sense, but the king has to rule through his ministers, and his ministers are chosen by the majority party in Parliament. That hadn't fully happened yet as of 1787, but they're certainly on the way, which means that when you have prerogative powers vested in the crown, but they have to be exercised through a minister, there's still parliamentary control of a sort. But when prerogative powers are vested in an independent single person, that's something quite different. So this is an important problem, and the danger of sliding into some kind of monarchy, some kind of autocracy are obvious. And then to make things more, why do they pause? To make things more awkward, who is the presiding officer at the Constitutional Convention? It's George Washington, whom everybody knows is going to be elected the first president of the United States. So just like any comment anybody makes now about the president, we always think, they think we're talking about Donald Trump, right? Well, anything said in that room about the dangers, how are you going to talk about the dangers of tyranny from the president with George Washington right there? And to make matters worse, the presidency was the most unprecedented part of the constitutional plan. The delegates knew what legislatures looked like. Most of them had been and served in their colonial and state legislatures. They knew what courts were like. Lots of them were judges and lawyers. And so those were things, those weren't, I'm not going to say these are easy, but at least they had precedents. But there had never been a powerful, independent, Republican, single executive over a large expanse ever. Not in the history of the world. They had no precedents. And the precedents that they could look at were not happy ones. There's the king. Well, we don't want that. There were the colonial governors who were almost to a man detested. Right? That's not good. How about the state governors between independence and the Constitution? Well, they were so lamentably weak, Madison calls them ciphers, right? So they're not a model for anything. The closest thing was the governor of New York, but even the governor of New York's powers fall way short of anything that the that the framers of the Constitution have in mind. And then to make matters worse, Madison, who is the best theorist in the room and is the one who came up with the Virginia plan, hadn't given it much thought. He wrote a letter to George Washington just a day or two before he takes off for Philadelphia. And in that letter, he lays out lots of his theories about what the Constitution should contain. And then he says, I have given very little thought yet to the executive, either to how it should be constituted or to the powers that it should have. And so here we are, the hardest task, the unprecedented task, the one on which the fate of republic or tyranny rests, and our best theorist doesn't have anything really to contribute. No wonder they paused. Right? Well then, John Rutledge of South Carolina, pay attention to Rutledge because he probably knew more about being an effective executive than anybody else. He was wartime governor of South Carolina during the Revolution and was universally regarded as the most effective wartime governor. The British occupied South Carolina. It was one of the bloodiest theaters of the war. The legislature couldn't meet, so what the legislature did was that they voted to make Rutledge, make the governor a, quote, dictator, which meant that he had the powers of legislature, executive, and judiciary all rolled up into one. At that time, dictator didn't mean, I mean, we think of like Mussolini or Pol Pot or, somebody like that. At that time, they thought of the Roman history, so they were thinking of people like Cincinnatus, who were given all the powers of the republic temporarily for the sake of an emergency. And so Rutledge single-handedly ran South Carolina during the darkest days of the Revolution. And as soon as it's over, he resigns. So he's just like Cincinnatus. And so when Rutledge is one of the first to speak right after the pause, and says other interesting things, but he's for having a single executive, which is kind of monarchical, a single executive, but not for giving him the powers of war and peace. James Wilson, the best lawyer at the convention, said he does not consider the prerogatives of the British monarch as a proper guide in defining the executive powers. Note that he, just like Pinckney, when he sees the word executive, he thinks of the prerogative powers of the king, but he says, we don't have to go by that. We don't have to give all the prerogative powers. We can do this on our own. And then Madison proposes, well, why don't we just let Congress decide which prerogative powers the president will have? That would solve our problem. But the delegates were so spooked by what Pinckney said and by the problem that they just went the opposite direction. And so they vote to create a single president, but all he is going to be able to do is execute the laws passed by Congress, plus to make appointments that are not vested anywhere else. By the way, he couldn't, at this time, he didn't have the power to appoint judges, didn't have a power to appoint ambassadors, which is the way you conduct foreign policy. So his appointments are like, Postmaster General. And he also was given a veto. But note that this is a theory under which the principal job of the president, principal function of the presidency, is to check bad things that the legislature might do, rather than to actually accomplish anything. So this is an extraordinarily weak executive that they create. And then after June 4th, this is the very beginning of the summer, they don't return to the powers of the presidency. It's left just like this until late July, when they appoint a committee to put everything together, called the Committee of Detail. Well, a lot of people have been fooled by this because it sounds like the Committee of Detail is just going to deal with details. Actually, 2/3 of the total content of the Constitution is written by the Committee of Detail, and they were not shy about breaking new ground. And look who's on the committee. John Rutledge is the chair of the committee. James Wilson is on the committee. Edmund Randolph, who wrote the original, or at least introduced the original proposal, is on the committee. All three of them advocates of a strong executive. But remember what Rutledge, and I think implicitly, what Wilson and I think implicitly Rutledge had said is we do want a strong, independent executive, but not with all of the prerogative powers, right? And so what did they do? My theory, we don't know, by the way. They met behind closed doors. The presidency was created behind closed doors. There were no minutes of what they did. We do have a first draft, and then scattered sections of a second draft, and then we have a third draft. So we know, and with a lot of handwritten emendations on those drafts. So you have to, it's sort of like detective work to figure out what they did. Here's my theory, which is I think they either had a copy of William Blackstone's Commentaries on the Laws of England, or they knew Blackstone well enough, because Blackstone lists some, depending on how you count them, roughly 42 specific prerogatives of the king, right? And the Constitution explicitly, or at least by strong implication, deals with at least 39 of those, and I think really, if you read it correctly, 41, that is all but one of the prerogative powers. And some of them are given to Congress. So these are royal powers. Isn't this interesting? Royal powers held by the executive in the British system are actually given to the legislative branch in our system. Such important prerogative powers as, look, make war. Remember what Rutledge said, he doesn't think the president should have the power to take us to war. A bunch of others, right? In fact, I believe it's 13 of the 27 specific powers delegated to Congress were actually royal powers held by George III. So lots of congressional power is actually royal prerogative power. Now it's being given to the legislature. Then some are given to the president. You can see the list, I won't bother reading them. Some of them are cast as duties, but then the king had some duties too, so this is not revolutionary. Duties are, I think in some ways this is just a polite way of giving him power. So for example, he's given the duty, he shall recommend measures to Congress, right? But when you tell him he shall recommend the ones that he thinks, it goes on to say, that he thinks in his estimation would be in the national interest, that's really giving him the power to propose legislation. It's introduced, we know from how it's introduced on the floor, that was done to kind of make Congress, make it look as though he's not sort of invading Congress's prerogative to legislate when he does this. It just softens it. If it's a duty, then maybe it'll slide down a little bit more easily. So the president gets a certain number of the prerogative powers, and then a number of the prerogative powers are eliminated for the federal government altogether. For example, the king is the head of the Church of England. Well, we're not going to have a national church, so we don't do that. The king had the prerogative power to create and give away titles of nobility. Well, we have a clause in the Constitution that says we're not going to do that. So a number of prerogative powers are killed, but the rest are divvied up between Congress and the president. Or this is my theory. So I contend, and then it's interesting, even the prerogative powers that are given to the president are carefully described and qualified in ways that make them less potent than those of the king. So what I see is that the whole process in the committee of detail is they do want a single president that's going to be independent and has a lot of power, but what they're doing is they're being very careful about what powers the king is going to have to make sure that he isn't going to have be a king. And among the powers that are denied to him are the ones that are most likely to produce a subversion of the republic and a creation of an autocratic system, things like the powers of war and peace. So look at some examples here. The president is commander-in-chief of the Army and Navy of the United States and of the militias of the several states when called into the actual service of the United States. Well, that sounds innocent, doesn't it? The king is commander-in-chief, generalissimo is the term Blackstone uses, is commander-in-chief of the Army and Navy and of the entire militia of Britain, right? The president isn't. Well, does that matter? The president is only commander of the militias when they're called into the actual service of the United States. Elsewhere in the Constitution, there are only three Congress gets to decide when the militia will be called into actual service, and only for three specific reasons. Right? Now, we think of militia, how powerful are they? Right? Well, let me tell you, at the beginning, the regular army under Washington, the standing army of the United States rarely got to be more than 1,000 men, and they were mostly stationed on the frontier. The number of men in the organized militias of the states comes to 500,000. In what I think is the most chilling of the Federalist essays, number 46, I recommend you read it, Madison is arguing against the claim that the federal government is going to be so powerful that it's going to overwhelm the states. He makes a number of arguments, and he ends with a military argument. And he says, well, look, if the federal government and the states are at loggerheads, who's going to win? And he calculates the maximum number of soldiers that the United States can support in a regular army is 25,000, up against 500,000 men, and he points out these are going to be men using their own arms. This is what the Second Amendment is really about. They're men having their own arms, commanded by officers of their own choosing, because the states choose the officers. Right? And so, in other words, the president does not have at his command the larger part of the military might of the nation, unlike Julius Caesar. Right? Totally unlike Julius Caesar. Instead, the president is confined, right? Except in times of actual war, when Congress has called the militias up. So it's really a very clever, very intricate system to prevent the presidency from devolving into a military dictatorship. I'll try to go faster. Pardons are, of course, in the news these days, but note that there are serious limitations on the president's pardon power. He can't pardon in cases of impeachment, and those are going to be high crimes and misdemeanors, the ones most important to the survival of the republic. And he can only pardon for offenses against the United States, not offenses of the states. If you look at the initial criminal code passed by the first and second Congresses, there were only like 8 offenses against the United States. Treason was really the only important one, right? But most offenses are not. And even today, roughly 95% of criminal prosecutions are carried out under state law, not under federal law, and the president can't pardon those. That's why, just sort of as an aside, that's why the activities of the Attorney General of New York with respect to Donald Trump's financial affairs are in many ways a much bigger threat to him than anything in the House of Representatives, because the Attorney General of New York can act, and the President of the United States does not have the power to use doesn't have the pardon power. So there's more to be said about the structure of Article 2, but I look at my watch and realize that if I continue telling you what I think is interesting about Article 2, that you won't have the chance to ask and talk about things that you think are interesting. I believe, and it's sort of my scholarly brag, that the structure of, that once you understand the structure of Article 2 in the way it was actually laid out by the Committee of Detail and the delegates, that it at least casts a lot of light on modern day separation of powers conflicts, such that they don't all have to be decided on the basis of sort of the particular case-by-case, highly politicized way in which the court so often decides these, that they're actually principles that take us a long way to deciding what look like pretty difficult questions. So if we had time, I actually have slides about all kinds of modern disputes you might be reading about in the newspapers. But instead of that, I'm going to invite you all to ask me or talk about the questions that may have arisen in your own minds about the powers of the presidency. I think you should come up to the microphone.
We have a microphone here in the center aisle. We do have a bit of a custom in the school. Good, we have students coming up first, so I'll let the students ask first.
In your personal opinion, do you think the way they divided power was the best at the time? And do you think it should be reformed given the changes in technology?
Wonderful questions. Was it the best at the time? I do think these were men with unusual, I think they were talented. I think they did the best they could. Now, there are other provisions of the Constitution that everybody understood to be just rank compromises, and that they didn't imagine that they were doing the best thing, like slavery, for example. They knew that was just a nasty compromise. For the presidency, I don't see any of those compromises. I see it, they were doing the best they could. Whether they could have done better, I have no idea. Should it be reformed is a wonderful question, because, let me just tell you why reform is so hard. We might actually all agree, and I'm pointing to the audience, but what I really mean is that we Americans, all 300 million of us, or however many there are, we might actually all agree that some reform, that there are changes that need to be made. But put us in a room and we're not going to agree on what those reforms are. And it is going to tear us apart, right? Just like Britain is being torn apart about Brexit right now, it's going to be very difficult. And there's something to be said for sticking with a system, even with all of its flaws, even if it's not ideal, because it's something we can all agree upon and move ahead with. And I think that's probably what I would say. In fact, I think that is what I said.
Hi. Really good question. That's actually like what my question was, but I made a different one. So I guess I've just have this personal fear with prerogative powers and the declaration of an emergency. And I wonder if I guess I also refer to the current presidency, if declaring an emergency for less and less clear reasons kind of creates a foot in the door concept where those prerogative powers can be really executed, and especially when you have a lot more power with technology and not actual population.
So there are no emergency powers in the Constitution. And that wasn't an accident. I think the framers are with you on that. What we have is a statute, Actually, we didn't, and the presidents didn't even purport to exercise emergency powers outside of a declaration of war for the first 100 some odd years. It's a product of the 20th century, and especially Woodrow Wilson and the progressives. And then in the post-Watergate period, I think it's 1976, to try to control the presidency and bring the presidency under more congressional control, the Congress passed the National Emergencies Act, which provided that any of the various statutes, and I think there are about 160 statutes that give the president unilateral authority in times of emergency to do things he couldn't otherwise do. According to the National Emergencies Act, all of those then become subject to this statute, and it provides how the president will declare the emergency, and it allows Congress to override the emergency by passage of a congressional resolution, not subject to the veto of the president. It does not specify anything. It has no standards for what an emergency is. But it has Congress has an immediate vote, and they can say yes or no. So Congress gets to override the declaration of an emergency. Well, about 7 years later, the Supreme Court, in a very important case called INS versus Chadha, holds that legislative vetoes are unconstitutional. Now, it didn't have the Emergency Act in front of it. It had a fairly trivial statute in front of it. But legislative vetoes are unconstitutional, and we could talk about reasons, but it doesn't matter. The reasons don't matter. Fact is, legislative vetoes become, and now the National Emergencies Act no longer looks like a control of the president. Now the president is able to issue these emergencies with no standards whatsoever, and the only way Congress can override it is by passing something by both houses of Congress and submitting it to the president for veto or signature, which is, and even then, my legal opinion is that those statutes might well have become unconstitutional, because when one portion, that is the legislative veto, is held unconstitutional, right? There's a doctrine in the law called severability. The courts ask themselves, when one part of a statute is unconstitutional, can the rest of it continue, or does the whole thing have to go down? And the answer to that is, it's not very satisfactory, but it's the courts guess whether a reasonable Congress would have passed the statute in the absence of the unconstitutional thing. Well, I don't know, but I think they would never have passed the National Emergencies Act and without a legislative veto. That was really the whole point of the statute, was to bring the president under control rather than to give him this enormous power. Then what did they do? A couple years after Chadha, Congress then amends the statute to have a two-house veto with signature of the president. So that's now the law, which is totally useless, right? Completely useless, but Congress did it. And so when Congress complains that Donald Trump is declaring national emergencies for reasons that don't seem like emergencies to them or to us or to me or to you, right? They have nobody but themselves to blame. Now, I share your sentiments on this. I think they ought to repeal it. I think it's something the framers would never have gone along with. Not that it's unconstitutional, but just that it is exceedingly unwise.
But to repeal it, they would need, it
They
has to be able to
repeal
override
it,
an
it has
executive
to,
veto,
you know,
and executives might not want to give up the.
That's right, but they could repeal the whole thing as a rider to something else that the president wants. So that the politics of a total repeal are actually in some ways easier than the politics of the exercise of a legislative veto.
Yeah.
I guess you might have already kind of answered this, but my first question was going to be, do you think that the founding fathers, if they would have seen, or the framers would have seen the presidency in its aspects today, would they have approved of it? Or would they, and if they could see it, what do you think they would have done differently in terms of the powers of presidency, or potentially removing the presidency or something along those lines? More of a hypothetical.
You know, crystal balls are one thing for the future, but reverse historical crystal balls are, how do we know what they would have thought? I think there are many aspects of the modern presidency that the framers would actually approve of. Some things that were enormous successes. The biggest danger in republics is for the executive to have a military takeover. I mean, that's what's happened. More republics have ended that way than any other. We successfully solved that problem. Now, a second problem is demagoguery, right? Demagoguery is a popular politician who appeals to the passions and prejudices of the populace rather than to enlightened reason. Now, demagogues are in the eye of the beholder, of course. We don't know, we can't say this person is or that person isn't. But they were aware of the problems of demagoguery. They thought they were making demagoguery less likely by virtue of the Electoral College, where you would have the president actually chosen by electors who would be persons of substantial intelligence and weight in the various states, and they would be making the decision, and they are much less likely to fall for demagogic tricks than the population as a whole. But we have evolved a system in which the electors just vote for who carry the state. And so that important check against demagoguery is gone. I don't think they like that. I think they probably would have preferred their own system, but how do I know? They did, I think, there's some aspects of the presidency I think they would be thrilled with. I think that they understood that one of the things that makes the legislature not work very well is it's very hard for them to formulate sensible plans. There are just too many people. And that's why they gave the president the power to recommend measures. And then Alexander Hamilton did this under the Washington administration. So he had his plan for the bank. He had his plan for money, credit, and banking. He had the plan for the mint. He had planned for taxation. So he gave them plans. Then they were able to amend them, but and do what they wanted. But it's a good system to have a plan that you're working with rather than just to have a committee where a bunch of people are throwing out ideas. And I think that that feature of the presidency has become much more important over time. And except, in the last two presidencies, when Congress doesn't really pass much of anything, but looking back now for the last 50 years, that's become an important part, and I think they would probably like that. Something I think they wouldn't like is the growth of a bureaucracy which is so sort of in and of itself, it's self-regulating, and the people stay in it forever, and they don't really represent anybody, and the special interests, by the way, not just from one side. Special interests include, it's not just industry. Environmentalists are a special interest too, but whoever sort of insider baseball politics dominates the bureaucracy. And I don't think I'm quite confident, this is the most confident statement I'm going to make. They hated the British ministry system precisely because it was, this kind of, it was had neither the virtues of actual open parliamentary consideration nor the virtues of a king who sort of rose above politics. It was very political, but bureaucratic, ministerial, political. They hated that. I think we have a lot of that. Our government looks a lot like that. So I don't know. I think it's a mixed bag.
Great. Corbin.
It's a good thing you just started talking about the bureaucracy, because my question is related to what I've been reading recently, which is the new book from Justice Gorsuch that is all about his views on the Republic. And I just finished the section where he takes a very oppositional stance to the Chevron, Auer, and Brand X decisions. And I'd like to hear what your take is on those decisions, or just the concept of legislative delegation towards the executive that's been going on lately.
So for those of you who aren't into inside baseball, the Chevron, let's just talk about one of those, Chevron, which is the most important of them. The Chevron Doctrine is the idea that when Congress passes a statute and it's not completely clear, which is most of the time, that the agency which is charged with enforcing that statute gets to interpret the statute, and the courts will defer to the agency's interpretation if it's within the bounds of reasonableness, even if the court is pretty daggone convinced that the agency got it wrong. And this is especially important when the agency changes its policy because of a change of administration. And so what it means is you have a statute that hasn't changed, but under the Bush administration, it means one thing. Under the Obama administration, it means something else. And this is, I think this is and Gorsuch thinks that, which is more important than what I think, thinks that this is a serious offense against the rule of law. The idea of the rule of law is that there should be settled, established law, which is then faithfully interpreted. But this way, essentially, the laws get made up by each administration and each agency as they go along. And I tend to agree with Gorsuch on that. I think it's not the way the system was intended to work. Now, there is going to be executive interpretation of the law. This has happened. Hamilton, for example, and there were a number of statutes that had to do with the Department of the Treasury that were not entirely clear, and Hamilton interpreted those. But what Hamilton said is, my interpretation will carry unless there's a case in the courts that goes to the contrary. He did not assert that the court should follow his interpretation, just that his interpretation would carry unless and until it went to court. Now, he was probably confident enough to think the courts would agree with him because of the persuasiveness of his interpretation. But the Chevron Doctrine isn't about persuasiveness, it's about power. And I think that's a problem.
Great. Jonah.
So my question was on the nature of the executive power as we kind of move forward, which is considering the general tendency of the federal government, and in particular, it seems the presidency to have gained power. Do you expect this trend to continue as we move forward? And then do you think that as the presidency gains further power, it might eventually get into a position where it can slip from the grasp of Congress and possibly fulfill that dreaded fear of the elected monarch?
Well, I actually think that the people are going to decide this question. The presidency certainly has increased in power. Under Trump, a lot under Obama, a fair amount under Bush. It's a long-term thing, but for the most part, I think it has less been the president's usurping power as Congress ceasing to be an effective body in and of itself. And that's for a lot of reasons, but one of the big reasons is political polarization, because there was a time when the important members of Congress cared as much or more about institutional considerations as they did about partisanship. Just as an example, I teach a debate that took place in 1986 in which President Reagan instructed his officers not to enforce a particular statute passed by Congress because he thought it was unconstitutional. The House Judiciary Committee has a debate about this, And they unanimously condemned President Reagan's action, unanimously. The Republicans along with the Democrats, because in their view, it's essential that the president comply with statutes passed by Congress, and the fact that the president may personally think it's unconstitutional shouldn't matter. Why would a Republican vote against President Reagan this way? Well, there might be a Democrat president next time, and so we care about the institutions, right? That doesn't happen anymore.
Thank you.
And the reason it doesn't happen is that politicians are not rewarded by their constituents for voting that way anymore. And so it's up to us to want to have a revival of constitutional principles. It's the only, and if not, maybe we will slip into some other form of government.
That's the party system is another innovation beyond the framers' original
It is.
plan. Just like
And we could
changed
talk
the
about the
electoral
party
college,
system too. I tend, on the whole, to think that the party system was a useful innovation that helped rescue the Constitution, but the party system as it is turning into something I think quite different than what it used to be. Just quickly, what political parties used to do is that they used to moderate politics. So each of them is a coalition, and the parties would mediate the claims of the various portions of their coalition and moderate them and try to present a party platform that would appeal to a majority of the American public. And so the parties perform this mediating function, moderating function, and it was because they were controlled by professionals who wanted to win the next election, and they would do it by appealing to the middle. Right? Today, the parties are no longer controlled by professionals. They're now controlled by ideologues, by the base, right? And this is true both Republicans and Democrats, but the base is now the most important, and the base doesn't care. The base would rather have the kind of president, the kind of nominee that they most want, rather than to have somebody who might appeal to the other side. And so the party system has become destructive of the very thing that used to make the party system an advantage, in my opinion.
Yeah.
To go back to that first question of Reformation, as you said, reforms need to be made according to the American population. You also said that attempting to make these reforms would tear America apart. However, that doesn't change the fact that these are reformations that need to be made. So should the American population not even attempt progression because of that fear? Is fear a justifiable reason to stay in this state? And then if push comes to shove and America finds on a heavy day that not making these reformations is no longer a choice, what do you think we should do in the meantime to better prepare us to make the reformations that would shape the nation?
So I'm certainly not against reform. What I do worry about is like having a new constitutional convention, which a lot of people are for. I think I just shudder to think what this American culture today would do, what people would say, what they would propose. I think the divisions would be huge. I think that maybe I'm just too much of a cautious person, but I don't think it would work very well. And I actually think international experience supports that. We've had a lot of countries emerge from dictatorship in the last 50 years, and very frequently what happens is that they adopt a temporary constitution, just sort of throwing something together and don't worry very much about it because they'll then plan to have a new one. Israel is a great example. And then, have there been any successful examples of one of the post-totalitarian republics going back and actually creating a new constitution? I think the number may be 0, but even if the number is only 1 or 2, the experience isn't very good. And so what they tend to do is they continue getting along on their supposedly temporary constitutions, and it works okay.
Thank you.
You mentioned that pretty much everybody in that room knew Washington was probably going to be the first president. And the example he set during those first 8 years and the letter he wrote leaving office kind of set the tone for the presidency for a long time. How much of the fact that they knew he was going to be a president, how much do you think that influenced kind of the powers they gave and what they decided to give up, knowing the individual who was going to take on that role first?
Of course, we don't know. I do suspect that they were willing to be a little more sketchy about the powers of the presidency because they knew Washington would be the person setting the course. But they were warned against this on, I think it's June 4th, Benjamin Franklin is opposing something that was proposed, and he said, the first man at the helm will be a good one. After that, we don't know. There was a time when they were proposing a 1-term, but long-term, I forget now whether it's 7 years or 9 years, and a delegate from South Carolina said, well, that's fine if it's a good president, but that's way too long if it's a bad one. And so they listened to that, and the impeachment was debated a lot, and the two sides of that were those who realized presidents could be treasonous, they could conspire with foreign governments, they could be corrupt, they could do all these things, and so some sort of provision for impeachment and removal seemed reasonable. On the other hand, if it's too easy to do that, then the president ceases to be independent, and one of the things they really wanted was that the president be independent of Congress. And so those are incommensurable things, right? You can't have both, full protection of impeachment and also full guarantee of, and those are just opposites. And so they adopt the high crimes and misdemeanors formula in order to create what looks like a pretty high bar. But on the other hand, it's still a political process.
Good, perfect. We have time for one more. So,
Sir,
great.
you mentioned that in William Blackstone's commentaries on the English law, he enumerated over 40 prerogatives of the monarch, and that it's commonly accepted that the Constitution enumerates about 39 of those as an analog for a Congress or the president, but that in your reading, you identify 41. Could you tell us what the other 2 are?
Yeah, sure. And by the way, it's not commonly accepted. Very few people have even noticed the numbers. I think, I'm aware of like 4 or 5 scholars who have even looked at the Constitution from the point of view of these prerogatives. So the one that is clearly not addressed is the power to remove officers, that is to fire officers. And so the king clearly had that power, and it's not mentioned. I do not have a theory as to why, because people talked about it. They were aware of the problems. It wasn't that they just didn't notice it. If they didn't do anything about it, I don't know why, but it is, I think, not coincidental that the one Blackstonian prerogative not clearly mentioned leads to the first constitutional debate in the history of the United States over the removal power in the so-called decision of 1789. The other 2 are control over immigration, and what is the other that's a possibility, which I don't think this was an accident, and I actually think that they believed that the states would exercise the immigration power, and so they didn't have to address whether it would be the president or Congress. Congress has the power to control naturalization, but there's no mention of immigration in the Constitution. And the other is I'm kind of like Governor Perry. I have 3 proposals, and I've just forgotten one of them.
Boy, the removal power comes back because that dispute between the executive and the legislative powers is one of the grounds a century later for the impeachment.
Absolutely.
The only other
It's
impeachment we've
it
had
becomes
for Andrew
become
Johnson.
with us. That's right.
Yeah.
So, you know, they make the
Impeachment.
decision in 1789, but they revisit the question right after the Civil War, and Andrew Johnson says, I'm going to fire the Secretary of War, and Congress impeaches him for doing that, right? And then the Supreme Court seems fairly clear about it in a decision in the 1920s, which they then, I mean, in this enormous, like 240-page monstrosity of a scholarly opinion written by none other than, you know, William Howard Taft, the only Chief Justice who was ever also president. It's like a behemoth of an opinion. And then just a few years later, in 7 pages, they take it all back. In what looks like a jab in the eye to Franklin Roosevelt and Humphrey's executor, and where the reasoning is just pathetic. But Humphrey's executor is with us today. And even today, this is a big issue. So there are these so-called independent agencies that the president can't fire the members of. And why he can't is beyond me.
Good. Join me in thanking our guest. I have a few closing remarks, but they're... So I'm all that stands between you and a reception, but I do have a few closing remarks and thanks. And a reminder that not only you have food of one sort in this direction, and then you have the Federalist in this direction, so you can choose. All of the students here, again, should get information about the school, but members of the community as well. For example, we have a summer program for high school students, the Civic Leadership Institute. And I have not mentioned our website yet, but there it is at the bottom of this banner, but it's on the literature we have outside. We have a video archive of all of our speaker events, including our 3 Constitution Day lectures. We have a link to our podcast there called Keeping It Civil, all kinds of information on the website. And speaking of our speaker events, this is an annual lecture of itself. We have a Martin Luther King Day lecture every spring semester. And then now into our 3rd year, we have a major speaker series. We entitle the whole project across 3 years now the Civic Discourse Project. But each year we have a theme within it. And the theme this year is citizenship and civic leadership. That speaker series kicks off next week with Robert Putnam of Harvard University, September 25th, right? And then early October, I think it's October 7th, we have 2 prominent journalists debating questions about the media's responsibility to think about citizenship and civic education. And that's David Leonhardt of the New York Times and Ramesh Ponnuru of AEI and National Review. So those are the next 2 events in the speaker series. Finally, thank you to our terrific team of people that organizes all these events. I'm just the pretty face that gets to stand up here and enjoy working with these terrific speakers. But first thanks goes to Dr. Carol McNamara, who is our Associate Director for Public Programs of the school, coordinates all of this. And then Catherine Sheffield, who is our Special Events Manager for the school. And then the staff as well, all these folks wearing maroon polo shirts. You know, Taylor and Bobby and Kim are often here. Joe and JC, our communications staff, our student workers. So thanks to all of them. And with that, please don't forget to see our friend Kathy Krish and the Federalist reception in this direction. Join me one last time in thanking Judge Michael McConnell.